So welcome everyone. This is New Leaf Solicitors' first Q&A session. So we're all here today to answer your questions on family law and wills and probate queries. Let's have a quick round of introductions. So let's start with Kelly. Kelly Bruton, she's a family solicitor. She's based down in Southampton, Fareham. We have Amy Aris, who is a solicitor specialising in wills and probate and is based in Towcester. And we have Pauline O'Rourke, who is a solicitor based in Birmingham, and she's a specialist in family matters, as is Mark Perrott, who is based in Leicester, and I said he deals with family law. And then there's me, Amanda Weaver, and I'm based in Rugby and Leamington, and I deal with family. So we've had a few questions that's been put to us already. So each of the team are here to answer those queries as we go through it. But if you have any additional questions, there's obviously the chat function, and I'll keep an eye on that and answer any questions that come up on the chat in the chat rooms. So let's start with Kelly, who's been asked about, can my court hearing still take place?
Good morning. Yes, in answer to the question, your court hearing can still take place. The family courts are still open. All hearings will continue to be dealt with. Some non-urgent hearings may be adjourned until a later date, but many hearings are being dealt with remotely, either by telephone, Zoom, or Skype. I have first-hand experience of this, as I've actually dealt with 2 hearings remotely myself this week. I dealt with a hearing on Monday where I represented a family client at a telephone hearing, and it was dealt with by way of a telephone conference where all parties took part in the telephone conference with the judge, and we were able to successfully agree directions as to how the case would proceed going forwards. I have another remote hearing which is listed on Friday, and what we've done in that case is we've been able to agree a consent order in advance between myself, my client, and the other party who is acting in person. So what we've actually done is already submitted a consent order to the court, which the lay magistrates have agreed that they will consider on Friday, and they've excused the attendance of the parties. So in summary, yes, your court hearing can very much still take place. It's just a different way that we are working at the moment.
Great.
Thank you.
Thank you, Kelly. Should we take a wills question now then? So Amy, you've been asked, so can I still make a will during the lockdown?
Yes, you can. We're taking instructions on video conference call or Zoom, and I'm sending out drafts on emails. I've got lots of inquiries, lots of new clients wanting to get their will in order. And then when it comes to signing wills, people are either asking friendly neighbours to come and watch them sign. So you need 2 independent persons to witness you signing a will. At the same time that you sign, they must sign. So they have to watch you sign and then sign at the same time. And so neighbours are signing through open windows for clients. Or I've also had clients come to my front garden. I've set up a little desk in my front garden, and I've put the paperwork down on the table in the front garden. They've come and signed, and my husband has acted as second witness. So yes, still very much possible to get your affairs in order, and we are most certainly open for taking new instructions.
Great stuff, thank you, Amy. So this, another question we've had, obviously money is a big issue at the moment with a lot of people who are not working as they usually are. So Pauline, you've been asked a question about finances, obviously about how you fund a case during these tricky times.
Yes, I've been posed the question. The question was posed in the way that, can I make my husband pay my legal fees? And that the legal fees in connection with, it's not just the divorce, it's the financial aspects, which is the bigger part of the picture. The financial aspects of the divorce being how to treat the family home, the savings, other assets, there could be businesses, even pensions if they're in payment. We've got an asset there, which is a liquid asset, which the husband has access to. Maybe he has access just to the sole savings. And this is not gender specific, but I'm going to refer in this specific question, it is the wife who is the poorer party. She poses a question, husband's got the money to pay his lawyers and continue with this case. She's got no money. How can she fund it? Well, there are ways and means with applications in court, but just generally, I would like to address some self-help remedies first. Do you have access to a credit card is one of the questions I would ask. If you haven't, now's the time to consider applying for a credit card, because you will get an interest-free period, hopefully with new credit cards. Maybe use that to pay your solicitor's bills each month. Can you extend your overdraft? Can you apply for a bank loan? Can mum and dad help even? These are self-help remedies. If it's yes to those kind of sources of financing, then go for it. There are specialist companies out there which do offer litigation loans. Litigation meaning you can fund your case to make an application or continue in court. But they're a niche product, they're not ideal for everyone, and they do have some upfront costs and costs each month paying the interest on the drawdown of the loan. So there are things you can do on a self-help remedy, and bear in mind you're not going to want to rack up debts, but debts are taken into account in the overall picture of the finances. So, you know, if you've had to incur debts to pay your legal fees, you're not going to be criticised by any judge or any party, particularly if I've got anything to do with it, because you've had to pay my fees somehow. So that's your self-help remedies. If truly that isn't available, then there are, in my view, two courses of action you could take in court. The most obvious one is the new legal services payment orders, which came in the last couple of years or so, and this is an application you can make in court, in proceedings, to say I cannot find funding in any source to continue my action in court, to take action in court. It would be reasonable for my husband to pay me a sum of money, either each month from his income or a lump sum of money, so that I can be reasonably represented in legal proceedings. You have to overcome the hurdle first, and it's quite some hurdle here. You can't find funding anywhere else. Your solicitor's not prepared to wait for payment of their fees on a deferred basis, so your only source is to get it from your husband. If you do make an application, and I would assess whether there is a merit in success, then you're likely to get your costs paid, particularly if your husband is pretty wealthy, he's behaved in a pretty not so good manner, and he's deprived you of your money each month, and it's crying out for him to help you with your fees. So we've got a remedy there. You can apply in court and get a court order. Another way of getting money from your husband each month to assist with your reasonable outgoings is, in the interim, pending the outcome of the financial settlement overall, you could apply for urgent interim maintenance. That's not maintenance for your child, but it's maintenance for yourself, spousal maintenance, but it's in the interim, pending the outcome of the bigger picture. Since we've had the introduction of these legal services payment orders, you can't tack on in your application for this maintenance each month your solicitor's bills. It's not as clear cut as that. But your reasonable outgoings each month, such as your rent, mortgage, utilities, debt repayments, are reasonable outgoings, and you may well be successful on a merit assessment of getting interim maintenance. Now, go back to what I said about incurring some borrowing costs, some credit card costs. In my opinion, they could be absolutely included in an interim maintenance application, and therefore by backdoor way you're going to get some funding to pay your solicitor's bills each month. Either application is means appraised, so the judge is looking at the means of the husband and the means of the wife, so it's not a clear cut that you're going to get, it's not a given you're going to get an order. But very useful remedies, and again on the self-help, your good solicitor would most likely make an offer or make a proposal that the husband pays on a voluntary basis, and very often that will twist his arm and you will get a lump sum payment towards your fees from him, or some voluntary maintenance each month to assist, because that husband will know, his legal team will know, that you can be successful in not only getting an order but getting costs ordered against him. So there you go, self-help remedies, and there are 2 applications I would consider making in court. I hope that assists.
Thank you, Pauline. We've also been asked a very pertinent question. I was about children arrangements again during this lockdown. So, Mark, you've been asked about the question, I want to see my children. How do I do that?
Yeah. I've been asked particularly what my options are. First of all, people question whether they might need legal advice. In my view, it's very sensible, because often things have happened which we would want not to have happened prior to a court application being made. First thing I would say is to encourage people to take some advice. We offer appointments on a fixed fee basis, or before that even, we can give some general advice over the telephone which may help. By way of example, I spoke to a friend of mine last week who's got 2 young children that he's not seen, certainly one of them, since January. His son was about 11 years old. Something had happened between them. In my view, even though he's a friend, he hadn't managed it particularly well. And I just reminded him that he's the adult and his child is a child, and suggested a practical way he might want to resolve that. So I've left that with him and said, give me a ring in a couple of weeks and let me know how you've got on. But I know from knowing him that he has a good relationship with his children, and I suspect that'll be enough to stop that becoming a big issue moving forward. And what we do in the fixed fee appointments is gather lots of information. So firstly, it's cost effective for a potential client to have a fixed fee appointment, and they can give lots of information that will prove useful in advising them. There are things that clients often don't consider, which are going to be matters that a court may take into a concern, and the typical welfare issues are alcohol misuse, drug misuse, domestic abuse, which is very prevalent in the news at the moment, any local authority involvement, historical and current, and mental health difficulties. What we do with that information is then give potential clients the options as to what they can do next, and we'll discuss those options. The first of which is to give them the tools to self-help, and as I've just given a practical example of a friend, those self-help tools may be of some assistance. The second stage would usually be a letter to the other party setting out that client's position in terms of contact, with a view to arranging a mediation appointment with a mediator. The purpose of mediation is to enable 2 adults usually, but also if the children are old enough, to also involve the children in that mediation session, to help them to reach an agreement which is workable moving forward. Ultimately, if none of that is successful, then there is always the option to make an application to the court. You've already heard that the courts are still operating. I would suspect on the ground level there is going to be some time delays. So very often when people want to see the children, time is a big issue. And the primary concern for the court is always the welfare of the child or children. And if you as an individual work from that basis, you won't often go far wrong. Court applications can be time consuming. There can be delays even in normal times. And what lots of people think, sometimes not correctly, is that the court is ultimately going to solve everybody's problems, which is not always the case. And it takes sometimes some thinking outside the box to resolve things that the court can't necessarily do. So I hope that's been of some use. If you want to have a chat, you're more than welcome to contact me.
Lovely, thank you, Mark. One additional question, which I'm happy to answer, is someone's raised the question of, can I start a divorce during lockdown? And the simple answer is yes. As Mark and Pauline, we've all said, that we are open business as usual. So we're available by these Zoom meetings or old-fashioned telephone. So if you have any queries, we're obviously here by telephone. We can set up a meeting. Yes, we can get all the paperwork and everything ready, and proceedings can be lodged with the court, but as Mark said, it's likely to be a little bit of a delay. The court are working on a bit of a skeleton staff, so there could be a delay there. But yes, we can continue with the divorce or any kind of cases during the lockdown. So I hope that has answered all of your queries. We are here whenever you need us. So if you have any questions, by all means, contact us, and hopefully we'll see you again at the next Q&A session. So thank you from all of us. Thank you.
Thank you.